My lords, my lady, I submitted before lunch that the 1981 Act, Section 40, does not make statelessness unlawful or prohibit statelessness, as submitted, and as submitted by my learned friend. And the submission I wanted to turn to next was that neither does the 1961 Convention. And in fact, and perhaps surprisingly, but for reasons I'll come on to, I hope illustrate, by making the Section 40 subsection 2 power subject to Section 44, in other words, requiring that the Secretary of State be satisfied that the order would not make a person stateless before she can exercise the 42 power, the Act goes further than the Statelessness Convention. And the reason that is so is explained by Lord Wilson in Al Jeddah in a earlier passage of his judgment, which we hadn't looked at before, where he describes the background and the legislative history.
I was trying to remember this morning, because I had at the back of my mind that somewhere somebody had said, actually, the Act goes further than the Convention. And it's Lord Wilson.
It is, my lord, and can I ask you to turn it up? It's tab 3, and it's paragraph 18, page 207. At paragraph 18, Lord Wilson starts by noting the fact that by 1964 the UK had resolved to ratify the 1961 Convention, passed the 1964 Act in order to do so, and made a declaration of the type permitted under Article 8.3. And you'll recall from the convention that you looked at this morning, which is behind tab 29, Article 8.3 expressly reserved to signatories the right to make a declaration to deprive individuals of their citizenship and rendering them stateless in certain particular circumstances, one of which being if they had conducted themselves in a manner seriously prejudicial to the vital interests of the state. And the United Kingdom did indeed make such a declaration, as Lord Wilson notes. And that declaration, paragraph 19, noting that it had been made, was translated into the original version of the 1981 Act, which my Lord Justice Lewis referred earlier, paragraph 20, which provided that an individual could be deprived if their conduct had been seriously prejudicial to the vital interests of the state, at letter D.
Yeah, and it goes back to the Aliens Act, doesn't it?
Yes.
Passed in the First World, either side of the First World War, which is referred to in paragraph 14 of his judgment. That's where that came from, I think, that particular exception. So that was a position under the original 1981
Under the original 1981 Act. Then, in 1997, the Council of Europe promulgated the European Convention on Nationality. Article 7 of that convention preserved the ability of states to deprive for conduct seriously prejudicial to the vital interests of the state, but required that you could not do that if the effect was to make that individual stateless. So in other words, it applied the statelessness prohibition to the to deprivation on that ground. Now, paragraph 22, Lord Wilson explains that the UK did not ratify the European Convention, but the intention was to do so, or the aspiration was to do so on paragraph 22, just by letter F. And as a result of that aspiration, fresh section 40 and 40A were substituted into the 1981 Act. The grounds for making an order for deprivation were reduced to two. The fraud ground, 43, and 42, contrary to, prejudicial to the vital interests of the state. And they were both made subject to the statelessness prohibition. So at that point, the Act sought to prevent deprivation decisions taken on prejudicial to vital interest grounds if the effect would be to render the individual stateless. But that was in order to comply with the European Convention on Nationality, not in order to comply with the 1961 Statelessness Convention. Because the 1961 Statelessness Convention expressly permitted states by declaration to deprive individuals on that ground, even if it made them stateless. Picking it up at G, the seriously prejudicial to the vital interest formulation got amended by the 2006 Act to conducive to the public good, which is what is the formulation we now see as in section 40. But the essential point is the one that Lord Wilson makes at letter H. Fresh subsection 4 prohibited an order on the second ground if the Secretary of State was satisfied that it would make a person stateless. It is clear, therefore, that in enacting the subsection, Parliament went further than was necessary in order to honour the UK's existing international obligations. So it's...
If it had simply been a question of complying with the Statelessness Convention, you wouldn't have needed subparagraph 4 at all.
Well, you certainly wouldn't have needed it. No, you wouldn't. You wouldn't have needed to apply it to 42.
Because if it was vital to the interest of the state or conducive to public good or whatever, then the convention entitled you to make a declaration rendering somebody stateless in those circumstances.
And we did.
Yeah.
And up until we get to the point where the European Convention sought to go further and say you can't make someone stateless even on that ground.
Yeah.
The Act was amended in the event the European Convention on Nationality wasn't ratified.
So we don't need section 44 at all for the deprivation of public interest or fraud. And the fact that we put it in was a choice because we anticipated doing something for the Nationality Convention, not because we had to because of the Stateless Convention.
Yes.
So we don't get any help then, do we, when we look at 44 or indeed other provisions?
No.
From the Statelessness Convention.
And importantly, my learned friend gets no help for the submission that you've got to read 44 in order to read it down in order to comply with 8.1 of the Statelessness Convention as some sort of general prohibition on statelessness, because that's not what the 1961 Convention requires in the context of people who are being deprived on conducive grounds.
Yeah.
And the reason I trouble the court with all of this, my lord, is that statements such as the one that you were shown in B2 just before lunch by my learned friend, to the effect that section 44 is the way we comply with the 1961 Convention, are not quite right. And we didn't point any of this out, I regret to say, to Mr. Justice Jay at first instance. And so his observation to similar effect that, section 44 prohibition reflects or gives effect to the 1961 Convention is not quite right either.
Can I just check though? I haven't got the 1981 Act in front of me now, but I read it yesterday, and there were a number of complicated things that could justify you in removing citizenship, of which two were public interest and fraud, but there were other things. I haven't got them at my fingertips. Was Section 44 in the 1981 Act required, at least in part, for some of the grounds on which you could in 1981 deprive somebody of citizenship?
Yes.
So Section 44, or is
Yes. Well,
did have an effect for that purpose, though.
Yes, so the equivalent provision in the original version of the 1981 Act is section 40 subsection 5.
Yeah. And that had to be there for some of the grounds.
Yes, and in particular, the Secretary of State shall not deprive a person of British citizenship under subsection 3 on the ground mentioned in paragraph C of that subsection.
That the 12-month imprisonment.
Exactly so, my lord. If it appears to him that the person would thereupon become stateless, and 3C is within a period of 5 years from the relevant date, been sentenced in any country to imprisonment for a term not less than 12 months.
Just playing devil's advocate then, if we had to interpret section 40 subsection 4 to deal with that category, we may have to look at the Stateless Convention, and if Mr. Southey is right that it prohibits it completely, and therefore under the old 1981 Act we'd have had to give it the interpretation that Mr. Southey wants us to give, then the fact that we've gone beyond it and applied it to other things as well isn't relevant, because we can look at the Statelessness Convention to try and work out what the consequences of section 44 is, if you follow me.
I think so, my lord, but it still wouldn't be an answer to the primary argument, which is that the statute is clear in what it says.
That I understand, but your submission at the moment is that it wasn't intended, that the section 40 subsection 4 and the other provisions weren't intended to qualify, but they were originally, when enacted, intended to qualify it, albeit in one respect, that we had a ground of deprivation which we couldn't act on if it would render somebody stateless, and the equivalent of section 40 subsection 4 was there to stop that. So Parliament must have meant it to have a context there, so it is relevant to look at the Statelessness Act. Do you follow me?
Yes, I do.
Ah, right.
I think. Oh, well, I think I do, my lord. So in the original enactment,
Yeah.
insofar as Parliament wanted to preserve grounds for depriving an individual,
Yeah.
which went beyond the declaration,
Yeah, they had to have
they would have to,
yeah.
for those preserved grounds, in order to faithfully reflect the convention, preserve a prohibition on rendering the individual
So the
stateless.
prohibition
for
must
those
have had
reasons.
some meaning in 1981, and there's no indication its meaning in terms of the effect or consequences of it was changed in the amendment provisions. So it is relevant to look at what the Statelessness Convention means, because it would have told us what section 40 subsection 4 meant in 1981, and none of the amendments were intended to change that, would be Mr. Southey's argument, I imagine.
Yes, but that doesn't run though, my lord, because in the version of the statute that we're looking at, 44, the 44 prohibition is applied only to the 42 non-conducive ground
I
for
understand
deprivation,
that.
and that's never had any. That's got nothing to do with the convention or the legislative history.
For the article's purposes. Forget about that. There was a provision in 1981 which was in similar terms, not identical terms, but similar terms to the section in 40 subsection 4. Therefore, in 1981, that section had to be given meaning. And it had to be given meaning in the context of Statelessness Convention, because that power in 1981 was being used in situations where the Statelessness Convention stopped you depriving somebody of citizenship.
Yeah.
So it had a meaning in 1981, and that meaning hasn't changed in its various incarnations. The fact it's gone wider now and applies to other things has changed, but the meaning that it had has been applied to those other things.
Well, my lord, my response to that is it's not that it's gone wider; it's that they're two completely different provisions
Let me
dealing
put a
with two
different question
completely
to you
different
then.
things.
On the 1st of January 1982, was there a meaning to section 44, which would have to take account of the statelessness convention.
Well, it was section, back then it was section 40, subsection 5B.
Yeah.
But yes.
Which appeared to the Secretary of State and so on. But that would have to be given meaning on the 1st of January 1982.
Yes.
In regard to the statelessness convention. And although the words have changed, the purpose underlying it hasn't changed. So we do need to look at the statelessness
But
convention.
wouldn't that be only in relation to the fraud exception? Because in relation to the conducive to the public good, or how it was then described, the convention did not require the convention permitted a country to deprive somebody of their citizenship in those circumstances,
Yeah.
where it was conducive to the public good, irrespective of statelessness.
Yes, my lord.
So at that stage in 1981, so far as that was concerned, the one that we're on now, because it's the only one left, the convention wasn't relevant to that.
And that, yes, my lord, that's the submission I'm attempting to make. I'm so sorry, my lord, but can I at least attempt to articulate this? What we are referring to as the predecessor of 44, which was 45B in the original 1981 Act, did a very specific and particular job.
Yeah.
It faithfully reflected the prohibition on statelessness in the Statelessness Convention,
Yeah.
in respect of 3C, depriving somebody of their nationality if they'd had a 12-month period of imprisonment in the preceding 5 years. That's what it did. That's
So
all.
when we interpreted section 45B in 1982 or 83, we would have had to give those words a meaning that took account of the statelessness convention.
You would.
Yes.
Because
Now, moving on from that, although the words have changed slightly, the same English words appear under a reply to different things now, to which the convention doesn't apply.
Yes.
But we've already decided, or we would have decided in 1982 what those words meant, having regard to the convention.
Yes, but my lord, the reason that you would have had to take account of the convention in respect of the old 45B was that 45B derived from the convention obligation.
Yes.
It was the way we gave effect to our convention obligation. The current 44, for the reasons I've attempted to submit, does not derive from the
I
convention. It's
understand
got
that.
nothing to do with the
I know,
convention.
I understand
Which is
that.
what Lord Wilson says.
Yeah. My point is a quite different one.
It's a semantic point. I think what my lord is saying is that the same words,
Yes.
pretty much the same words are used. So whether or not you're giving effect to an obligation that comes from the convention in the later case, Parliament's chosen to use the same language. So if the language that was used originally in 1981 is informed by the convention, why isn't the language that's now used similarly informed by the convention, even though it's not giving effect to an obligation imposed by the convention?
And my answer to that, my lady, and I apologise for the length of time it's taken me to grasp the point. But my answer to that is that the only reason you interpret legislation by reference to international instruments is if the legislation is designed to give effect to the international instrument. It can't be because the wording of the statute that you're seeking to interpret happens to be similar to or equivalent
wording
to
of the statute-
earlier legislation which was designed to give effect to an
Why
international
not? Because
instrument.
the later statute, we assume, or we've decided, gives effect to the same meaning of the earlier statute, and then you have to look at what the earlier statute meant. And the earlier statute did have regard to the convention.
But the later statute isn't purporting to give effect to the convention,
No, but it
because as Lord
wasn't-
Wilson said, it goes beyond what the convention required.
I don't think it's a point we need to travel with us any further, but the question I'm asking is not answered by what you say. I'm
Oh,
not saying
sorry,
interpret the new power by reference to the convention. I'm saying interpret the new power by reference to the words of the old power. What did the old power mean? That was influenced by the convention. That's the simple, easy point. But don't worry about it. It's not going to win or lose this case.
Well, again, I apologise for my failure to grasp it, my lord, but I'm so sorry about that.
No, I was talking across you, it's my fault. I suppose there might be a point lying behind this, which is, in any event, if you're construing primary legislation, to what extent can the language of the primary legislation actually be affected by the words of the convention? And it may be only if the language of the primary legislation is ambiguous.
Well, my lady, I would agree with that. I mean, I haven't. It's in the bundle. I haven't taken you to the recent Supreme Court judgment in SC, where Lord Reed, as everyone knows, reminds us that international conventions are not enforceable contracts, and litigants can't rely upon their terms. So the question then becomes, and this takes me back to my failure to answer my law's point when I thought I was answering a different question. The question then becomes, well, what relevance do they have?
Yes.
Well, they have a potential relevance if you're looking at a provision of domestic law which is attempting to give effect to that international instrument. You can then read, subject to my lady's point, if there's some ambiguity there perhaps, you can then read the domestic law provision in light of the international instrument and work out what it was intended to mean. But this none of that helps with 44 for two reasons. Firstly, there's no ambiguity in the domestic provision. The condition precedent is the condition precedent and couldn't be more clearly expressed. And secondly, there's no point looking at the 1961 convention to assist you, even if there was ambiguity, because 44 has got nothing to do with the 1961 convention.
Could I look at the wording of section 45B in the 1981 Act to help me understand the meaning section 44?
Certainly, my lord. Well, shall I hand?
The convention for interpreting section 45B in the 1981 Act.
Have we got the text of 40?
No, we haven't.
We have actually.
I do have it, my lady, and I'm very happy to hand it up.
You've got 3 copies.
Don't worry,
I do.
it's a very small point, but
I have 2. I'm so sorry.
don't worry. Well, I read it yesterday. I didn't memorise it, but I remember most of it. Don't worry about it. I think it's taking up too much time on a peripheral point.
I mean, I should say, of course, my lord, I don't suggest this particularly helps. Any of this helps. I don't get any support from the 1961 convention, or indeed anywhere else. I found my argument on what the Act says. My learned friend, for reasons that I hope I've explained in my submission, doesn't get any help from the convention either. The only reason I thought I ought to descend into this slightly
Rabbit hole.
this rabbit hole was because both the court at first instance in this case and the Court of Appeal in B2 have made what is no criticism, the rather blithe assumption that 44 is our way of applying the 1961 convention, and I didn't want this
Whereas
court
historical archaeology demonstrates that it wasn't.
exactly, it doesn't, and I didn't want that misapprehension to continue to flow through the jurisprudence in this
Can I
particular.
then ask you another question, to which your first answer is, this is not relevant, and I've already written that down. But you'll answer it anyway, Mr. Shelton. Do I get any, what do I understand 81 to mean? Does it mean shall not deprive, so there can never be a period of time, even if initially you made a mistake, in which a person is stateless? Or does it mean you shouldn't do it and try and put it right as soon as possible, please?
Well, the second, my lord, in my submission, but I
That's
don't.
what we call a dolly drop.
I'm struggling to find a particularly good reason for that, other than that it suits my argument.
Yes, that's what I thought. I thought I'd do the questions and the answers. I thought it would save time and misunderstanding. But that's what you would say, is it's not tied anyway to undoing a deprivation that shouldn't have happened but did.
I do say that, but of course, my lord, as you've already anticipated, I say it doesn't matter, because Parliament's decided what the Secretary of State's got to do in this context, and has set that out in 44.
Well, if we're doing it, you ask the question and give a variety of answers, it saves us time.
It does save a lot of time.
Multiple choice.
Thank you. Yes, multiple choice is definitely my preferred format. I'm going to leave the Statelessness Convention if I may, and then just on the basis that I've now submitted, I hope, that most importantly the Act, but also the Convention, do not prohibit statelessness or make statelessness unlawful in some absolute or blanket way. What is required is that the Secretary of State do what Section 44 mandates that she does, and is satisfied that a deprivation decision will not render the individual stateless before she makes it. And if she does that, as she did here, no suggestion otherwise, that decision is a lawful one. The second reason, the second set of reasons why that conclusion is, in my submission, clearly correct, derives from the nature of an appeal before SIAC. So, in allowing an appeal on the basis that the preliminary issue of statelessness is determined in the appellant's favour, SIAC is not declaring the deprivation order to have been unlawfully made. It's not quashing it. It is simply finding that as a matter of fact, and on the evidence as it now stands, the effect of the order has been to render the individual stateless, or the effect of the order at the point it was made was to render the individual stateless. And as the court will know, and as this case illustrates, statutory appeals on statelessness grounds are concerned with the entirely factual question, often informed by highly complex expert evidence, of whether the individual has, as a matter of fact, been rendered stateless. It doesn't engage with the lawfulness of the decision to make the order on public law principles. Now, as my lord, my lady will have noted, and as indeed was picked up in the grant of permission in this case, the judge referred to the recent Upper Tribunal Chicheri decision, in which, for our purposes, the tribunal relevantly found that when looking at the 42 question, is the individual conducive, then an essentially judicial review test should be applied per Begum to that question. Secretary of State, the Secretary of State entitled to reach her own view, and the tribunal side will only overturn it if it's irrational.
Yeah.
And the judge at first instance wondered what the outcome might be if that approach were applied. In other words, if public law principles were applied to a Section 44 requirement. In my submission, that doesn't arise, and it doesn't arise because I think it's common ground between both of us that on an appeal of this nature, on a statutory appeal of this nature, on the issue of statelessness for the purposes of Section 44, it is the job of SIAC to reach its own conclusion, not simply review, but reach its own conclusion as to whether or not the individual was rendered stateless. See Al-Jeddah
I was about to say Al-Jeddah.
paragraph 30. Exactly so.
Al-Jeddah
And although not expressly stated, see FAM as well, and every other case in which that's exactly what the court has done, with no suggestion that it was wrong.
And by definition, that means it's not doing anything else. It's not considering, for example, whether the Secretary of State's view was reasonable or had complied with her tameside duty. It's a straightforward, the end result was simply wrong.
Yes. And importantly, and very much generally to the benefit of appellants on these cases, importantly, that approach enables the court, the SIAC, to look at extensive evidence that was never before the Secretary of State when she took her decision.
Yeah.
Usually involving detailed expert evidence, as was the case here.
Because the judicial review, by definition, is a review, which is within a much narrower compass, and which must pay deference to the decision of the decision maker. Whereas this is looking at an issue of fact which is determined by the tribunal,
Yes,
irrespective of what the Secretary of State may or may not have thought.
quite. And so, my Lord, picking up the point raised by Lady Justice Laing earlier, not only is it unusual for a decision maker to be found to have acted unlawfully on the basis of information that he or she did not have at the time of the decision, subject to Thameside and duty to make a relevant inquiry. Not only is that unusual, it would be doubly unusual in the context of a proceeding of this sort, which is directed at a completely different question as to whether or not the decision maker acted lawfully, but is directed only to the objective factual position as it happened to be at the time of the decision. And so all of the cases that, and we haven't gone through them in detail, but the cases referred to by my learned friend in his skeleton argument, which trace through Anna's Minnick and Boddington principles in various not particularly analogous immigration contexts, provide no assistance in this context at all, because we're not talking about public law unlawfulness. And there is no conceptual difficulty at all in this context with the Secretary of State's decision being a lawful one in public law terms on the one hand, and yet being one that cannot be sustained in light of factual findings reached by the Commission on an Appeal.
Yeah.
Those two concepts sit entirely consonantly next to each other. And so the fundamental error, I respectfully submit, in my learned friend's argument from start to finish is that the Secretary of State acted unlawfully. The assertion that the Secretary of State acted unlawfully. That's not what SIAC found, and not what SIAC was engaged in trying to decide. And that is reflected, as the final part of this submission, that is reflected in the nature of the powers given to SIAC at the conclusion of an appeal of this sort. We've already dealt with the legislative history and the fact there used to be a suspensive power and there used to be a declaration that it had no effect. But the essential point is SIAC does not have the public law remedies that are available or made available to the court to deal with public law unlawfulness, most obviously a quashing order. All it has is the power to allow the appeal.
Nor does it have the powers that it has when it's doing a statutory review to set aside the decision.
No, quite so, my lady. Now, could I just deal with this one minor point in passing, although I acknowledge, of course, my learned friend did not make much of this. That at paragraph 24 of his skeleton argument.
Sorry, just to pick up one point, I knew it was somewhere. The point, and I don't think it's necessarily, I don't think Mr. Sully actually challenges this, but the point, your point about SIAC having to make its own decision on an appeal as on the facts is exactly what Lord Justice Longmore said in Hashi.
Yes.
Which I cited in the previous Court of Appeal judgment, paragraph 32. He says the court will then make up its mind on that evidence as SIAC did. So it's saying it's a decision on the evidence. It's not a public law review.
No.
Yeah. Okay. Sorry.
I was going to make a very short submission about paragraph 24 of my learned friend's skeleton argument, where he seeks to deal with the difficulty caused by the fact that Parliament had previously conferred a power to treat a deprivation decision as if it had never had effect, but had then withdrawn that power. And at 24(3), he cites a section of Hansard.
This is admissible.
Well, my lady, that's my submission. No, it's not, because the authority he gives for it, which is Wilson and SC, is about when you can look at parliamentary materials in the convention ECHR context,
Yes, to decide
for the
whether
purposes of
legislation
deciding
is
whether
compatible.
exactly so. That my lady's got the point. It's not admissible.
But how does it help anyway? Even if we could look at it, which I've just done, even though I'm not allowed to, it doesn't help, does it?
Well, no, in my submission it doesn't help either.
No.
This is talking about an appeal on Article H.
And then just finally, by way of sweep up on this primary submission, two points. To the extent that it matters, none of this analysis, or none of the analysis that I've urged upon the court, involves in any sense an abuse of language. Withdrawal does not necessarily connote treating as if never had any effect. Withdrawing an objection to something or withdrawing a deprivation of something, as perfectly ordinary language, implies its restoration from the point at which the prohibition or objection is lifted.
Well, I don't actually think, to be honest, the Secretary of State is restoring or reinstating anything. Section 1 tells you when you're British. Section 40 says you will not be British if an order is made. If that order is removed, then you are British because Section 1 says you are, and there's nothing to stop you being British.
Yes.
Actually, so I don't think she's reinstating anything.
Well, no, my lord, I would respectfully agree with that, which of course matches Mr. Justice Jay's analysis. The British citizenship of E3 and N3, Section 11 of the BNA, is conferred by operation of law. The only thing that was stopping them enjoying that status was the Secretary of State's deprivation decision. When the deprivation decision is withdrawn,
Well,
I'm going to try and not say restore.
But when the order is withdrawn, the obstacle to enjoying the full fruits of citizenship is also removed. But the reason why I can vote is not because the Secretary of State has reinstated me. The reason I can vote is because of Section 1. I was born in Britain of a British parent.
Quite, and so, my lord, my learned friend's submission that it's somehow telling that there is no statutory power of reinstatement is not in the least bit problematic for precisely that reason. Once the deprivation is lifted, the status quo ante applies.
I could take my birth certificate and my copy of the 1981 Act to the polling booth and say, register me now and vote, or I could do whatever I needed to do. There may be a bit of toing and froing, but the legal status derives from the Act, and there's no barrier to that because the barrier has been lifted or withdrawn.
Yes. And then finally, and this is only to make a point that I know has already been put to my learned friend, the consequences, benign, harsh or otherwise, for ZA or for anybody else affected in the intervening period must be immaterial to the proper construction of the statutory scheme. I would respectfully invite the court to reject the submission that where the consequences of something are found in an individual case to be harsh, that is something that can be taken into account in properly interpreting the legislation. Clearly not. So, my lords, my lady, that is my primary case, my primary submission on this appeal. The subsidiary argument, which was dealt with inevitably quite briefly by Mr. Justice Jay, was that even if that's wrong, and even if the decision to make the deprivation order is somehow rendered unlawful in a public law sense by SIAC's decision, it does not follow that it should be treated as a nullity. And the essential reason that it does not follow that it should be treated as a nullity is because that question, as the case is made clear, Seneji in particular cited by Mr. Justice Jay, that question, does an unlawful administrative act result in a nullity, has to be decided primarily by reference to the statutory scheme. And so the essential question is, does the statutory scheme indicate that Parliament intended that decisions taken otherwise than in accordance with the statutory requirements should be treated as nullities? And my submission, which as I accepted for Mr. Justice Jay and he recorded, inevitably overlaps with everything that I've already said. Plainly it doesn't, because if you look at the statutory scheme of section 40, there is nothing there to indicate that Parliament intended that if the Secretary of State is wrong, as a matter of fact, in her assessment of statelessness at the point of decision, her decision should be treated as a nullity. On the contrary, the statutory scheme indicates precisely the opposite, because Parliament was careful not to tie the decision to the absolute objective fact, but to the Secretary of State being satisfied with the position. So
I think
even
that's
if
the
you
same
get
thing actually. If we decided that it was allowed to be unlawful, the things that make us think that are likely to mean that the consequences is that it's a nullity. I think it really is just the same argument actually. If you get to unlawfulness.
I suspect so. I suspect so.
Okay.
Well, my lady, unless there's anything else I can assist with.
The stay that ZA wins because the SIAC decision was there and it had never been set aside
Yes.
before the baby was born.
Well, my lord, in respect of that argument, I don't think I can do much better than paragraphs 58 to 61 of my skeleton argument. But the essential point is that the one that's already been discussed today, that all SIAC did was allow the appeal. It didn't quash the decision, it didn't declare that it had no effect, and it did not make any order that could conceivably be interpreted as restoring citizenship to E3 or N3. It simply allowed the appeal. There was therefore nothing to stay. The only step that needed to be taken in light of the appeal being allowed was the Secretary of State withdrawing the decision once the appeal process had been exhausted. And so as far as E3 and N3's citizenship is concerned, nothing happened.
Because the order wasn't removed.
Because it was an appeal to the court.
The only thing, we come back, my lord, to the exchange we had just now. The only thing that is stopping E3 having citizenship under section 11
Is the subsistence of the order.
The order.
Is the order.
And because there was an appeal to the Court of Appeal, the order wasn't withdrawn by the Secretary of State.
No.
So it was still there.
Yes.
On that, a very minor point, but just so I've got everything clear in my mind, we've talked about the difference between the appeal against the decision and the deprivation order. And at one stage, one might have thought that weight was being put on the fact that there was no appeal provided against the deprivation order. But do you accept Mr. Southey's submission that there is an appeal against the decision? The existence of a lawful decision is a precondition to a deprivation order. So if SIAC could set aside or declare unlawful the decision that is the subject matter of the appeal, that is in effect implicitly a finding that the order itself is also invalid or unlawful.
My lord, I think I have to accept that because it's the inevitable, I suppose, flip side of what in fact happens in this case because in allowing the appeal, SIAC is allowing an appeal against the decision being the only thing you can appeal. And the Secretary of State acknowledges that what she has to do in response to that appeal against the decision is not withdraw the decision, but withdraw the order.
But just to change the facts, if it had been JR and we'd quashed the decision, I know we don't do that, but assuming it's an exceptional circumstance and we were allowed to quash the decision, and nobody thought to challenge the deprivation order, would you accept that the deprivation order was itself dependent on the existence of a lawful decision?
I think I'd have to accept that.
Okay.
I
No, I just
can't-
wanted to check. It's not a trick question this time. It's a genuine question. I didn't know the answer to that, so that's why I was asking.
Aware when the judge says it's not a trick question.
And in fact, I think Lewis LJ has been in exactly that position himself.
Yeah.
Well, I think the straightforward answer to the straightforward
Yes, yeah.
question, my lord, is yes.
So I can't put any weight on the fact that Parliament has provided for a decision, appeal against the decision, and it must have assumed that the order would remain intact as a separate legal entity. It's simply irrelevant. There's no significance to be attached to the making of appeal against one legal instrument but not another.
No significance that I urge upon you, my lord.
Or at least in the context of the arguments of this case,
Oh yes, I
No,
quite.
quite.
because there might be some
There might be
significance
on another
elsewhere.
case. Okay.
The only other perhaps obvious point I was going to make about the ZA's status in the period after the appeal, but prior to the withdrawal, is that it would plainly be a very odd situation if E3's citizenship was sort of switched on and off depending upon what stage the appeal process reached, because of course the appeal being allowed, the appeal was successful before SIAC but then overturned by the Court of Appeal. So on my learned friend's analysis, he was a British citizen from the date of the SIAC decision up until the handing down of the Court of Appeal judgment, at which point his citizenship got switched off again until the Secretary of State withdrew the order. And that would be an odd state of affairs. It would be even odder if citizenship should depend upon what, if any, interlocutory applications were made and or granted in the period while the litigation is progressing. But the essential problem with my learned friend's submission is that it's the deprivation order that's stopping him being a citizen, and it's only the withdrawal of the deprivation order that can return him to that status. My lords, my lady, those are my submissions, unless I can be of any further assistance.
Thank you very much, Mr. Chairman. So you would like to say?
My lords and my lady, can I deal with my learned friend submissions, trying to avoid repetition of what I've already said, and broadly in the order in which he made them. My learned friend, earlier in his submissions, in response, I think, to a question from my Lord, the Chancellor, indicated that one of the reasons, or accepted, I think, what was put to him, that one of the reasons for the phrase satisfied in subsection 4 is essentially the need for a practical system that can work in circumstances where urgent decisions may need to be taken. And we accept that that is likely to be the reason why the phrase satisfy or the word satisfied is used in subsection 4. But submit that that is precisely why, and or one of the reasons why at least, the issue for SIAC is different essentially. we would submit that the way in which this operates is that Parliament recognised that the Secretary of State might need to take a rapid decision, might well take a decision in circumstances where there was no input from the individual. So the individual wasn't able to, for example, call the expert that they ultimately want to call in their appeal and say to the Secretary of State, look, this Bangladeshi lawyer shows I'm being made stateless by your decision. And what clearly Parliament wanted to do was ensure both that the Secretary of State could take an effective decision, and also that there was then an effective review, essentially, of the decision that ensured, in fact, among other things, and I'll come on to the Statelessness Convention, but we would say compliance with the Statelessness Convention, and whether or not it's correct that there is compliance with the Statelessness Convention, that the individual was not stateless. And in those circumstances, in our submission, one needs to recognise that the clear intention was that the appeal to SIAC would be effective, and in our submission that means effectively that it will, among other things, determine whether or not the decision under appeal was a lawful appeal because of the fact it resulted in statelessness. Now, in that context, one of the points that has been raised, I think, was that points my learned friend makes is that the Secretary of State is essentially bound to act in relation to a finding of fact by SIAC. And I don't resile from the submission that I made this morning that if you get to a point after an appeal where it is found the individual is stateless, but there is no express provision essentially that means that the original decision was unlawful, there may be circumstances where the Secretary of State, they may be rare, they may be extremely rare, and it may well be the case that in past cases the Secretary of State has always conceded that they will comply with the decision of SIAC. But we do submit there may be circumstances in which the Secretary of State is entitled to say, well, I know that you've reached these findings of fact, I know that you've concluded, and I accept that the individual was stateless when I took my decision, but I have concluded that I am not willing to set aside the deprivation order because it was lawful when it was made and things have moved on. And that would be different in our submission to, for example, the situation where the Secretary of State, if we're correct, is bound to conclude the original order was unlawful, but then takes a further decision based on fresh material. Because if the Secretary of State takes a fresh decision, for example, the Secretary of State says, you weren't stateless when I took my first decision, but you now are stateless. If a fresh decision is taken, of course, there will be an appeal against that. And the individual will be able to come back to SIAC and say, not only was I stateless when you took your first decision, I am now stateless when you've taken your new decision. If the Secretary of State refuses to implement, or rather, it's not the right way of putting it, but refuses to withdraw the decision to deprive the individual of statelessness, there's no appeal against that. It would be a judicial review, and the Secretary of State would be entitled to say, well, I'm not withdrawing it because, as I say, I have good reason not to, given you are no longer stateless. My learned friend, I think then, in terms of issues I wish to address.
So, Mr. Sully, sorry to interrupt.
Yeah.
So does that submission depend on the premise that for some other reason that wasn't in existence at the time when the Secretary of State made the original decision, it is now clear that the person isn't stateless because they acquire the nationality of another country?
Not necessarily. All I'm saying is because if...
I mean, what I'd like you to confront is whether your submission is that if the Secretary of State knows, because of the decision of SIAC, that the person was stateless when the decision was made, there's been no change of circumstances, the Secretary of State would be entitled to maintain the order in the face of SIAC's decision. Is that your submission?
No,
All right, well, that's good.
No, can I be clear about? I'm obviously. Can I be clear about it? What I'm saying is this: if there's no change of circumstances, then I agree with my learned friend that I can't conceive of any circumstance in which it would be open to the Secretary of State, if his analysis is right, that effectively the way in which citizenship is restored.
That's all I wanted to understand, and I've now had a clear answer, thank you.
Yes. Just to be clear also though about the point I was making, the point I was making was in circumstances where there is a change of circumstances, the Secretary of State may be able to say, I am not withdrawing my order. And the distinct difference in those circumstances between my legal analysis and my learned friend's legal analysis is if my learned friend is correct and what's in issue is the withdrawal of the order, there is no appeal against those change of circumstances. If I am correct and the only way you could do that is by saying, I recognise the previous decision has now been found to be unlawful, I'm going to take a fresh decision, is it would generate an appeal.
Right.
Okay, we've got
In
that
those
point.
changes of circumstances.
I've got that point.
Thank you. Can I then go on to an issue which may be of limited circumstance relevance, but I probably need to address it given it took a little bit of time this morning, which is my learned friend's answer to the question my Lord Justice Lewis asked about whether or not the Secretary of State could say, I am withdrawing this decision and I'm withdrawing the decision with retrospective effect. In our submission, my learned friend's answer, which was to say you couldn't do that, is incorrect. The reason why it's incorrect, well, two reasons we submit it's incorrect. Firstly, he was concerned about the impact on third parties. We submit if there were to be a retrospective withdrawal, and in our submission there's no reason why there can't be, certainly not least because public law orders potentially have retrospective effect, it would then be for the courts to determine in any particular circumstance whether that had implications for third parties who had relied on the previous, on the order that was previously of effect. In our submission, if you can withdraw the decision, there's no reason why you can't withdraw it retrospectively, partly because it may be that the Secretary of State, when withdrawing the decision, recognises that she or he should have recognised at an earlier date that the initial decision.
Oddly enough, that's not your ground of challenge in this case.
No, I
You've
accept
not
it.
said she didn't consider it, or she should have granted, it's unlawful not to grant it retrospectively. You've simply said it's the automatic consequence of
And indeed, the argument
withdrawal.
is one which is, if anything, is contrary to your case before this court,
Yes.
which is no doubt one of the reasons why I'm running.
Well, my Lord, I there's one sense.
I didn't think of it, which is, I suppose, the other possibility.
Well,
You must have thought of it. I mean, you must have spent hours on this case. So it's just that you've decided that there's no possible illegality in a decision not to withdraw from an earlier date than the date of the decision, and that's why you're saying it's automatic. She didn't even have to think about that because that is what the law requires.
well, clearly we're arguing that it was automatic. I was probably just engaging with it on the basis of something that was once said to me by a Court of Appeal judge, which is I have an engaging habit of engaging with anything, everything. And so it may be that I'm, and it probably is, that I'm addressing something I don't need to address.
I don't
but
think
I
you
may
need to address it anymore,
Yeah,
frankly.
because it's not your case.
It's not your case, and it's not Mr. Sheldon's case, and it's just a question we asked, and we've received the answer.
Okay, all right. Well, can I then turn to the issue of the Statelessness Convention, whether section 44 goes, subsection 4 goes beyond that. The critical point, if one turns to Article 8 of the Statelessness Convention, Article 8, as my learned friend correctly points out, Article 8.1 is obviously the provision we rely upon. And Article 8.3 is the provision that is one of the provisions essentially that can be relied upon or can be relied upon by a state to justify a violation of, or a prima facie violation of Article 8.1. It is one of the provisions that allows the state to deprive someone of citizenship in circumstances that make them stateless. Now, it's concerned essentially with the retention of the right to deprive someone of nationality. And that has and it's concerned with the retention of the right in quite specific and limited circumstances set out in Article 8.3a and Article 8.3b. Now, when initially the 1981 Act was enacted, the 1981 Act, consistent with the United Kingdom's reservations, had provisions in it that reflected those reservations, which were intended to be consistent with Article 8.3. It also had other provisions that allowed deprivation of citizenship in circumstances that went beyond Article 8.3. And in those circumstances, statelessness was prohibited. That, in our submission, demonstrates that what was intended at that stage was compliance with Article 8, and indeed with the Statelessness Convention generally. What has then happened is that the UK has amended essentially its provisions that enable deprivation in circumstances where deprivation is said to be in the public interest. And those terms now, which are now subsection 2, no longer reflect the UK's reservations. We can hand up the reservation if you want. They used what might be thought to be broader language conducive to the public good. Now, what that means is that within that category of people who are conducive to the public good, there may well be people who would potentially have been eligible for deprivation under Article 8.3, but there may be people who are caught by it who are not eligible for deprivation under Article 8.3. And so the section 42, subsection 2, incorporates both a group of people who, as I say, may potentially have been eligible for deprivation in circumstances where they could be made stateless, and may also include people who couldn't be made stateless
I think it might help to have the reservations then.
Yes, sorry, can I?
I'm trying to think of a group, but I mean,
Yes.
Conducive to the public good.
Well, the categories initially, the reservation was. I'll wait actually for you both to, all three of you to receive. Yes. It's on page 4, the bottom of the second column on page 4.
Hang on, we've got what's UK?
Yeah. So there were 2 categories. Disregard for an express prohibition of
Seriously prejudicial the vital interests of Her Majesty.
Now, can I give an example? My Lord asked, can I give an example of a case that where conducive powers have been used but wouldn't necessarily come within these provisions? One example may be I don't, my lords may or may not, my lords and my lady may or may not be aware of this, but the conducive power has been used in the recent past in relation to one of the child grooming gangs. So they were used to deprive, and this was held to be lawful, someone who'd been convicted of, obviously very serious, I'm not underplaying the seriousness of the crime, but what might be described as a conventional crime, a conventional crime. Now, one can see why that might come within conducive. It might be more difficult to say that that was prejudicial to the vital interests of Her Britannic Majesty, as it was then. But the point about it is there is...
There's the possibility.
There's the possibility. Whether or not that's a good example, I would submit possibly
Well,
is.
I can see an argument both ways.
Yes, but there's the potential for uncertainty. Well, as soon as you don't use the same language, as soon as you use different language, which is what has now happened, and you clearly have departed from the language of the reservation, you have the potential both for the definition to be narrower than the reservation, but also the definition to be broader. And in those circumstances, it is not surprising that the protection against statelessness is then applied, because you are not any longer reflecting, you're no longer saying this is simply the reservation, essentially.
But your point is section 40 must have been intended to encompass the possibility at least.
Absolutely.
And therefore we need to look at the convention, because it's likely to have to be interpreted, you say, in a way that avoids, if that possibility arising, a breach occurring.
Absolutely. And it links back to the point that my lord made, which is when initially enacted, it seems to have, albeit it applied in a narrow range of circumstances, it appears to have been there because of the Statelessness Convention. No dispute about that. And it continues to apply, presumably reflecting the possibility that there will be an issue under the Statelessness Convention. I mean, in terms of Millennium Friends' interpretation, the dolly drop, essentially, question, in our submission, when one looks at the language of Article 8.1, which we now have in front of us, the language of Article 8.1 is unambiguous. It prevents statelessness.
No, it doesn't. It says shall not deprive a person.
Well, sorry, when I mean, I was using shorthand, but sorry, it's been a long...
That's the problem with shorthand. It's aiming at a contracting state. They're not supposed to deprive a person.
Absolutely, my lord. Well, and obviously what's an issue here is a deprivation, but it's an absolute... subject to the, obviously, the exemptions. It is an absolute bar on deprivation. It is not saying, well, the state can do it and then providing it's complied with its own domestic public law, for example. That would, in our submission, be inconsistent with Article 8.1 having an autonomous international meaning. It would be consistent with the general principles that apply to the interpretation of human rights conventions. And so, in our submission, it is clear that if there's a deprivation, perhaps because of the fact that the Secretary of State had limited information or for whatever reason, there is a deprivation that results in statelessness, that is in breach of Article 8.1.
Yeah.
Turning to the nature of an appeal to SIAC. First point that we would make is just to confirm that there is no dispute that, of course, what SIAC does on an appeal is analyse whether or not the individual is stateless on the basis of all the material before it, including material that was never before the Secretary of State. So that is not in dispute. It is it remains our position, as it was at all stages in this case, that one of the problems with that from Millennium Friends' point of view is that it appears to be his case, and we submit this can't be right, that if you want to achieve essentially a public law victory, or you want to set aside the decision of the Secretary of State on public law grounds, that you need apparently to apply for judicial review, which in our submission is has the potential effectively to undermine the effectiveness of SIAC. It's slightly odd that you should be potentially required to apply for judicial review and appeal, but be that as may be. In our submission, the critical point remains, and I'm not going to repeat it at length, why is there this jurisdiction of fact-finding? It must be, in our submission, because ultimately the section 44, or section 40 generally, prevents the individual being deprived of citizenship in circumstances where they are stateless. That is the basis upon which the fact-finding exists. In terms of Hansard, we do submit we're entitled to rely on it based on Wilson, but probably more critically in any event, because what's in issue is the purpose of the legislation. But in any event, probably more importantly, the reason why it is relevant is probably demonstrated by the scope of by the terms of the legislation. This is legislation. The amendment occurred, as I think is clear from the terms of the notes on the term. Sorry, yes, it's the notes to section 40A as now in force, which is at page 1126. You will see some footnote 3 that the amendment occurred in the Asylum and Immigration Treatment of Claimants Act. And you will see that the which was 2014, sorry, it's the Immigration Act 2014 rather, it's subsection 4, I think.
What are we looking at, Mr. Southey?
It's the footnotes to section 40A.
We're looking at this for what?
All I'm saying, my lord, is this. The context, which is effectively why we relied on the Hansard debate, the context of the repeal of the power to make directions in section 40A is that the underlying immigration provision, which was concerned with immigration appeals, it's the it was section 87 of the Nationality, Immigration and Asylum Act 2002, was in the context of immigration and immigration appeals. Section 40A3, as enacted when it included the power to make directions, was parasitic essentially on section 87 of the 2002 Act. And the repeal occurred when section 87 of the 2002 Act was repealed.
But if you're right, it should never have been there.
Well,
We never needed it.
well,
Why have a direction which enables you, may, to treat, not to quash, but to treat as if it had no effect, if in fact the automatic effect was
Well, I go back
unlawful.
to the point we made about Ahmed, which is if fundamentally the conclusion of SIAC demonstrates that the initial decision was unlawful, then that is effectively the consequence. And what the power that enabled SIAC to do was, and indeed the upper tribunal to do, was declare what the position was.
And what was I meant to get out of Hansard? I very naughtily read it after being told it wasn't admissible. But having read it, because I couldn't resist it, I couldn't see what its relevance was.
Couldn't see either.
Sorry, what
I
was,
read it as well.
well, it's,
Right, we all read it and we shouldn't have. So,
well, it's consistent with the point I was just making, which was that what this repeal was about was the underlying power in immigration legislation, in immigration legislation, to enable immigration judges, as I think they were
But
then.
the specific reason why it was repealed may not be of any assistance, but the point my lord was putting to you is why was it there in the first place? Because if it was there in the first place, then it runs completely contrary to your whole argument, because what it suggests is that it wasn't the effect. The effect of an appeal in relation to the facts would not be that the underlying decision was unlawful or was automatically, as it were, repealed retrospectively. Otherwise, why on earth did you need section 40A subsection 3 in the first place?
Well, my lord, at the risk of repeating myself, in my submission, what one sees, C. Ahmed, is that there is value in courts potentially being able to declare what the position is. Mm-hmm. But fundamentally, if I'm right on my analysis, that the reason why there is an appeal to SIAC in relation to statelessness is because ultimately Section 40 prohibits deprivation in circumstances where someone is stateless. Then that's what the effect of a declaration was. It was to declare what the position was. And the reason it talks about treating someone is because it recognises the point made in Majera, which is that ultimately there will be circumstances where third parties who relied on what was subsequently shown to be unlawful orders will still be able to be treated as that, will still be able to rely on the unlawful order because they acted in good faith at the material time. Finally, in terms of the harsh consequences to the individual, I'm not going to say very much more other than to make the point. Our point about that in terms of the interpretation is not specifically the particular impact on ZA, because that ZA, I suspect, was not within the contemplation of Parliament. The point about it is that what's happened to ZA is an example of the statute operating in the way it would inevitably operate if my learned friend is correct. It is a systemic problem, not just some sort of unforeseen consequence. And so to that extent, the fact that there are systemic problems with my learned friend's argument, and in particular, the potential for children to lose out in circumstances where their father or their mother just happens to be for a period deprived of citizenship pending the appeal, is relevant to interpretation. So it's not that this is some sort of unforeseen or isolated incident. It is a product of the system, the statutory scheme, if my learned friend is correct. Can I just turn around?
Yeah.
Well, I think that covers everything.
Thank you very much indeed. Well, thank you all very much for your arguments, which were extremely interesting. Won't surprise you to hear that we are not going to deliver judgment on return, even though it's only 3:20. We reserve our judgment, and I think it's fair to say no promises as to when. In other words, it's extremely unlikely.
not
I think
before
you'll get
Christmas, I thought.
this term. So it'll be next term. In the usual way, you'll get the judgment in draft for any typographical corrections, not for re-arguing the case, please. Also, please pay attention to the embargo, which is described now in lurid detail at the head of the draft judgment as to who can and can't have access to it and for what purposes. And if you can agree a draft order, please, at the same time as putting in the typographical corrections. I ought to say that one list of typographical corrections, please, between the parties, not two. I thought everybody understood that point, but last week I had two lots of typographical corrections, most of which repeated each other, which was, if I hadn't been in such a good mood, would have been extremely irritating. It only remains to say that when it comes, I hope you all have a decent Christmas break.
Thank you very much, Mark.
Rise.